Welcome back to This Week in Immigration. I'm Jordan Lapierre. This week, a new cap on refugees, the latest border apprehension figures, the push to overturn Flores, and now hiring immigration judges. All that just ahead. But first, remember, you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. And while you're at it, leave a review to help more people find this program. You can also stream This Week in Immigration on our website at bipartisanpolicy.org. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. Hi, Theresa.
Hi, Jordan.
Cris Ramón, Policy Analyst.
Hey, Jordan. How's it going?
And making her debut on This Week in Immigration, Project Associate Katie Sullivan. Hey,
Hi,
Katie.
Jordan.
Welcome to the show.
Thank you.
Theresa, I'll start with you today. The Trump administration recently announced its decision to set a cap of 30,000 refugees for 2019. That's down from 110,000 in 2017 and 45,000 this year. And in fact, I believe it's even a historic low. And I should say that's a cap, so the administration can choose to admit even fewer people than that, right?
Correct. So let's just talk a little bit about the process here. Under the Refugee Act of 1980, the administration every year is supposed to consult with Congress and then set an annual cap on the number of refugees it will admit to the United States that year. The refugee cap applies only to those who are processed overseas through the Refugee Resettlement Program. So that's the program that is worked in cooperation with the UN High Commissioner for Refugees, in which refugees are screened and vetted overseas before they are admitted to the United States. And the worldwide cap is subdivided into regional caps. So each region of the world also will have a subcap underneath that of the amount of refugees it will accept for certain regions. Traditionally, that cap has been on average between 70 and 80,000 a year. As you mentioned, President Obama, before he left, had set the cap for 2017 at 110,000. This administration, upon arriving, did lower that number in 2017 and then again last year. This year's cap is supposed to be 45,000 to date, and we are about 3/4 through the year. They've only admitted about 20,000, a little over. So they are on track to admit far lower than the actual cap. As you mentioned, the 30,000 cap would be the lowest cap set since the program was put in place in 1980. So we are accepting far fewer refugees.
So why is the administration making this push to cut refugee resettlement levels?
Well, as you remember, in 2016, then candidate Trump did make a point of claims that there was a significant threat from refugees arriving, particularly from Syria and the Mideast. He implemented his so-called travel ban in part to address that. If you remember, the travel ban would have zeroed out all refugee admissions from countries around the world for a period of time. And so there was a pause on them while that litigation was ongoing. So this administration has, if you will, had skepticism about refugee resettlement for a very long time. In addition, on making the announcement, Secretary of State Mike Pompeo indicated that there is a significant backlog in processing of asylum claims in the United States. Those are people who arrive here and then ask for protection. And it is the same officers, the Asylum and Refugee Corps, who process those two types of cases. However, traditionally, they have been somewhat separate processes, and resources devoted to one does not necessarily mean they're taken away from the other.
So the United States has historically led the world in terms of refugees resettled. So how might these lower numbers impact the long-term functioning of our refugee resettlement program and the prospects for refugees around the world?
So a couple of things. Since the creation of the Refugee Act of 1980, there have been a lot of organizations, non-government organizations, that contract with the federal government to aid and assist refugees as they're resettled throughout the United States. They provide them with legal advice, with assistance in enrolling children in school, finding work and housing, basically acclimatizing and acculturating to the United States. And that network has grown over time to meet the numbers of refugees admitted. With the drop in refugee admissions, the funding available to those organizations is being cut. And so many of these organizations are significantly reducing their capacity, their employment, and that could have long-term implications even if we later want to increase the number of refugees coming in, because it takes a long time to build up those resources. So that's something that will have a long-term implication for our refugee reprocessing domestically. Internationally, the fact that the United States has been a leader in accepting refugees from around the world has allowed us to essentially use that as a lever, if you will, a form of influence to persuade other countries to also increase the number of refugees they take in. We've used that as sort of a moral imperative, if you will, to say, hey, look, we're doing our part. We're taking all of these refugees in. You can do more because there are a lot of people in need. And so one thing I would say is that at 30,000, we're still taking in a lot more refugees as an absolute number than many countries, but we're taking in a much smaller percentage of refugees as a percentage of our population. And so other countries will look at that and say, you're decreasing the number of refugees at a time when we have more refugees and displaced persons around the world than any time in history. Why should we take more? And in fact, a lot of countries are looking at that. So that could cause the overall worldwide refugee crisis to increase, and that's something we need to pay attention to.
Thanks, Theresa. After the break, the latest border apprehension numbers. Chris, you're here with the latest data on apprehensions at the U.S. Mexico border. How is the flow of undocumented immigrants at the southwest border changing in recent months?
So the latest data basically confirms a lot of the trends that we've been seeing over the last couple of months. In terms of just total apprehensions at the southwest border, you've seen those increase after they've dropped off significantly through fiscal year 2017. They've been basically growing steadily through August of this year, and that number has continued to increase. When you're looking at more individual groups, because CBP actually sort of tracks also data for other types of individuals who are detained within this larger group, you've also seen generally an increase of unaccompanied minors that's been returning up there. And you've also been seeing a significant uptick in family unit apprehensions. Now, when you say family unit apprehensions, this means individuals who are traveling as part of a family. And so that's interesting because whereas with total apprehensions and apprehensions of unaccompanied children, those two numbers kind of are a reversion back to prior levels that we saw before fiscal year 2017. But for family units, that's actually been increasing. It's not a return to FY 2016 levels. It's actually just continuing to increase. So that's, I think, this little nugget of data that I think is really important for understanding what's been happening at the border.
Yeah. So we've talked recently on the program about whether these numbers support or undermine the Trump administration's claims surrounding the need for family separations. Does this data point in one direction or another with respect to whether that policy was an effective deterrent?
I think really it's a question of what piece of data you're looking at. And I think if you're going to look at total apprehensions, one can argue, well, it wasn't effective. It wasn't effective at all. And the Trump administration can say, no, our policy, we need that policy because numbers are going up. But really, if you're looking at it from a historical perspective, it's a matter of interpretation, because the way I see it is that these numbers are just returning back to historical levels that we've seen over the last couple of years. Remember, what we've been talking about this podcast is FY 2017 numbers were really, really low. And we've been talking about why that's largely attributed to the Trump effect, and saying that, the tough talk on the rhetoric on immigration, the tough talk sort of did have a limited impact on the number of individuals trying to enter the country and the apprehension numbers as a result. But with, like I said, with total apprehensions and UACs, that's just more of a return to form that we've been seeing. So it was good, simply put, those numbers eventually were going to return back to the levels that we've seen in prior years. I think what's interesting is that you're still seeing an increase in family unit apprehensions. And I think that this is going to be presenting a longer term challenge for U.S. officials, independent of whether you're saying it shows that the Trump policy was not effective in deterrence, or, this confirms that we should have that policy. And why is that? If you're looking at the data, a lot of these individuals from these family unit apprehensions are coming in making asylum requests. And for an immigration system that is long been accustomed to processing individuals who are detained because they're trying to come here for work. They're single Mexican men or sometimes single Central American men. For a system to do that, to shift from apprehending, detaining, and deporting those individuals to a system that now you're dealing with larger numbers of families, adults with children, individuals who are coming in here with asylum claims or potential asylum claims. For the system to be able to switch that quickly, I think is a real challenge for that. So I think this whole debate about, well, does this confirm that the family separation policy was effective or not, I think is kind of, it isn't this principal question that we should be asking. What we should be asking is the U.S. immigration system accustomed and equipped to be able to handle this really important change in the individuals who are coming here and trying to enter the country illegally?
And I think that segues nicely to our next topic. So after the break, why the administration wants out of the Flores settlement. As we watched the news of family separations at the border this summer, we heard a lot about something called the Flores settlement. Now the administration wants to overturn that agreement. Theresa, before we get into the why, let's start with a brief explanation of what Flores is.
So the Flores settlement is a settlement in a court case, Flores v. United States, that was settled under the Clinton administration back in the 1990s over the treatment of unaccompanied children who arrive at the border. At the time, there was not a particular process to handle those children. They were kept in adult detention centers along with unrelated adults, sometimes subjected to some very harsh conditions. And under the terms of this agreement, the federal government in perpetuity agreed to a set of standards for how it handles unaccompanied children at the border. In particular, it said that they would try to hold children in the least restrictive setting possible, turn them over to related adults as sponsors in the United States, make a continuous effort to release them from custody, and that the conditions under which they were detained had to be, for example, in facilities licensed for the care of children by state or local authorities, among other things. So the Flores settlement has governed how the government has managed to deal with children apprehended at the border for about 30 odd years. Under the Obama administration, when we first saw the increase in unaccompanied children and family units, they attempted to detain the children with their families in detention. And advocates brought a suit back to the judge in the Flores settlement, Judge Dolly G. in California, and argued that the Flores settlement should apply also to children who are with their families, not just unaccompanied children, any children in government custody. The judge agreed and said that they could not be detained for any longer than 20 days, even if they were with their family. At the time, the Obama administration argued that that could lead to separations of families where the children would be released and the parents detained in custody. Although the Obama administration did not do that as a regular practice, the Trump administration did, as we saw. And the Trump administration has insisted, and actually they're not the first administration to do so. The Obama administration tried to get out from under this settlement, so did the Bush administration. But the Trump administration finally did something that previous administrations did not. They actually proposed a regulation that would, in their mind, codify the standards, meet the requirements of the settlement, and by doing so, would essentially render the settlement no longer necessary. So under the terms of the settlement, if the government were to put into place regulations that meet the terms, then the judge in the settlement would vacate the settlement and the regulations would rule.
So let's get into specifically what it is that they're proposing to do and how that would affect family detentions moving forward.
Sure. So here are some of the big things. It would allow children to be detained with their parents. So right now, adults who are apprehended at the border attempting to enter illegally can be placed into expedited removal. That means they can be removed without going to an immigration court unless they make a credible fear. Until that credible fear determination is made, they are required to be in detention. This regulation would allow the children to be detained with them. And if they do not pass the credible fear test, which would allow them to possibly be released, they could continue to be detained beyond the 20 days. There is no new set length of time they could be detained. So theoretically, they could be detained until their case is heard or until they're deported under expedited removal. And that could be an indefinite period of time. We just don't know. In addition, it would allow Department of Homeland Security to use facilities that have not been licensed under state and local law, but would set a set of standards that had to be met that would be different than, for example, or similar to what might be required under state law, and allow for third-party auditing of this. So it basically allowed the department to self-license, if you will, family care facilities. It would expand loopholes that would allow them to place families and children in facilities that did not necessarily meet them standards when there was a quote-unquote emergency situation. And finally, it would tighten the definition of an unaccompanied minor. So right now, someone who arrives without an accompanying adult is deemed an unaccompanied minor. They are turned over to the Department of Health and Human Services, who handles them in the way that they're supposed to be handled. But if that child is later placed with a parent already in the United States, for the purposes of immigration processing and the law, they're still considered unaccompanied. This regulation would overturn that and would now say, oh, they're no longer unaccompanied. They're now accompanied and can be treated like other immigrants in the immigration court system. It would also say that once an immigrant turns 18, they no longer qualify for the protections due to unaccompanied children. So these are the provisions of a proposed rule. The comments are, the proposed rule allows for public comment on this rule for 60 days, so through November 6th, just happens to be election day. The public can comment on the Federal Register website on this rule. Following that comment period, the government is required to review all of those comments and respond to them. They don't necessarily have to change the rule in response to those comments, but they do need to address and respond to them. Following the publication of a final rule sometime after that, and there's no particular deadline, so it might be early next year, the court settlement says the court has 45 days to review that final regulation. The plaintiffs in the Flores settlement have an opportunity to file with the court whether or not they think it meets the requirements or they oppose it because it doesn't. The court will rule whether or not it does or does not, then allow them to release them from the settlement.
And Katie, you've been tracking how lawmakers and the public are reacting to this proposal. What are you finding?
Well, lawmaker reaction has been varied, but there seems to be a universal concern for the well-being of the children and the conditions of the detention centers. On September 18th, the Senate Committee on Homeland Security and Governmental Affairs had a hearing in which this was pretty clear. Members of both sides of the aisle expressed concern that this proposed rule not lead to children being detained indefinitely. This was a key part of Senator Hassan's line of questioning, and others agreed, including Ron Johnson, the committee chairman and a Republican. He expressed that the proposed regulation intends not to hold children indefinitely, but to extend beyond the current 20-day limit to allow for appropriate action to be taken case by case. The concern being that when we release families after 20 days with little consequence, it incentivizes others to immigrate illegally. ICE maintains that we need to eliminate the 20-day deadline because of this incentive factor. But on the other side, there's the concern, well, what's the new deadline? If there isn't one, where does that lead? So that's where the disagreement comes in. If eliminating that 20-day mark is the right route, lawmakers are also considering other strategies to alleviate the backlog of this system and eliminate the need to do that, like alternatives to detention, such as ankle bracelets, increasing the number of immigration judges, and supporting capacity building in Central America to try to solve the problem at its core. The public reaction has been a lot of concern for the children and their well-being. There were protesters at the hearing. There's been a lot of criticism from immigrant advocacy groups, and we do expect that if the regulation moves forward, there will be litigation.
All right. In a moment, beefing up the immigration courts. Recently, Attorney General Jeff Sessions announced that the Justice Department would increase the number of immigration judges by 50% to reduce the immigration court backlog. We've looked at a number of proposals to staff up the courts and whether they'd make a dent in that backlog. So Chris, how does this latest proposal compare to the other ones we've analyzed?
Basically, what we looked at, we also ran similar projections as we did for this earlier blog post that we did this summer, and found that increasing the existing immigration judiciary would reduce the existing backlog by approximately 59% by 2030. So that's a pretty good number overall. But if you remember when we were talking about this last time, is that there's a proposal in legislation proposed by Senator Ted Cruz to add 375 judges to the judiciary, and that effectively would actually wipe out most of the existing backlog. So this current measure that we have, taking a look at just the projections, it would make a significant dent. 60% is better than nothing. But I think if you're really thinking how far we have to go to really reduce the backlog, you're going to need a lot more than a 50% increase in the judiciary.
Yeah, so if 50% isn't going to get it done, how many new judges are really needed?
So when we were doing the projections, we basically came down to one thing, which is you need an excess of 100% increase in the number of judges that are going to be in the system. Once again, Ted Cruz's plan was 375, and I believe that's about 112 to 118% increase on existing capacity. So I think obviously more numbers means a better impact on the immigration court backlog. But I think if you're really thinking about percentages and what can sell, you need an excess of 100% in order to really reduce that backlog.
All right. Cris, Katie, Theresa, thank you for joining me. And thanks to you all for listening. A special thanks also, as always, to our producer, Emily Schrader. Please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. You just search Bipartisan Policy Center. Join us again next time on This Week in Immigration.